Thank you, everybody, for coming today. It is my great pleasure to introduce Judge Rosenthal and to welcome her to the Syracuse University College of Law. As many of you recognize from your interactions with her today, Judge Rosenthal is an example of someone who has a passion for law and, more importantly, a passion for the practice of law, something that you will all do. Her legal experience has a breadth and depth to it that really is unparalleled. A brief bio will give you the sense of that breadth and depth. After graduating from the University of Chicago Law School, Judge Rosenthal clerked for Chief Judge John Brown of the United States Court of Appeals for the Fifth Circuit. Thereafter, she entered private practice at Baker & Botts in Houston and eventually became a partner at the firm, which we all know is not an easy accomplishment. At Baker & Botts, Judge Rosenthal was involved in trial and appellate work at both the state and federal levels. In 1992, she was nominated for the United States District Court for the Southern District of Texas and has been a district court judge for more than 2 decades. In that position, she presides over cases that are as diverse as one can imagine given the size and the scope of that district. Judge Rosenthal's reach, though, extends beyond the bounds of the Southern District. In addition to her work as a trial court judge, Judge Rosenthal has been invited to sit by designation with the 3rd, 5th, 6th, 9th, and 11th Circuit Courts of Appeal. Not content to interpret and apply the federal rules of civil procedure on a daily basis, Judge Rosenthal has been deeply involved in the process of studying and reforming those rules so that they achieve what we hope Rule 1 aspires to, which is a just and efficient civil justice system. In 1996, she was appointed by Chief Judge Rehnquist to the Judicial Conference Advisory Committee on the Civil Rules. In 2003, she was asked to chair that same committee. During that time period, significant changes were made to the federal rules of civil procedure, including changes to discovery, class actions, and, with my own personal gratitude, rules that simplified and made the federal rules of civil procedure easier to read and understand. More recently, in 2007, Chief Judge Roberts appointed Judge Rosenthal chair of the Judicial Conference Committee on the Rules of Practice and Procedure. And in that capacity, she oversees the work of the advisory committees charged with proposing amendments to the various sets of rules that govern in federal court. Judge Rosenthal's efforts in connection with law reform, however, do not end with the federal rules. She is a member of the American Law Institute and serves as an advisor on various projects, including the Employment Law Project and the Transnational Civil Procedure Project. Judge Rosenthal's work and her commitment to justice has earned her well-deserved recognition. In addition to the recognition she has received for her work as a trial court judge, more recently she received the Lewis F. Powell Jr. Award for Professionalism and Ethics given by the Inns of Court. Judge Rosenthal's passion for law is reflected in all of her many engagements and accomplishments. She reminds us that there are no fixed boundaries to what we can accomplish when we find and pursue our passion, especially when that passion is civil procedure. Thank you, Judge Rosenthal.
That was a wonderful introduction, and I thank you for it very much. I thank all of you for the warm welcome I've received to Syracuse Law and for the opportunity to talk with some of you, get to know some of you, and learn from the great questions that you asked me this morning and that I hope you'll ask me this afternoon. This is my first time to visit your law school, and it's been a treat from start to finish, putting aside my time spent waiting for airplanes. I have loved seeing Dineen Hall. It's just been terrific. It's a smart and a handsome home for you in your law school education, and it has a personal connection to me. The Carolyn Dineen King, a senior judge on the Fifth Circuit, same Dineen, pictures in the lobby, is not only an esteemed colleague, but a very close friend. And she told me just last week, we were sitting talking over lunch about the dedication of the building, what it meant to her and to her family. She was so excited, and I cannot wait to get back and share with her the understanding that I now have of why she just was thrilled with what has been built in honor of her parents and with her family's name on it. I'm delighted to be given the chance to talk with all of you about one of our favorite topics, civil procedure. And Professor Harding's absolutely right. It is a ticket. It has taken me most recently, and will take me again, to Tunisia, where I am teaching Tunisian judges about various aspects of law, including and especially civil procedure. And Tunisian procedure is just fascinating. It is a reminder that what procedure does is answer questions that every legal system has to answer. And that's part of what I want to talk to you about. But I fully recognize that civil procedure is not the usual stuff of a talk that you have elected to hear or have been required to hear instead of eating lunch. So I thank you for that. I'm working on Civil Procedure, the musical, but it's not ready. So we get to just talk about civil procedure. And I truly do believe, as my title indicates, that this is the most important, the most valuable class you will take in law school. Now, I see a couple of you rolling your eyes. I suspect that there's some inward eye rolling going on that you're too polite to share. But I really do mean to speak to each of you. That includes those of you who want to do transactional work, who never, ever want to see the inside of a courtroom or what suit papers look like. I'm talking to those of you who want to do criminal law, who fully intend never to deal with civil disputes. I'm talking to those of you who may want to do litigation, but are thinking, I'm going to the state court practice, or I'm going to go do administrative law. I'm not going to need federal civil procedure. Even for you, for all of you, civil procedure really is the most critical class, the most important class you'll take. And I'm going to explain why, and I'll do so quickly enough that I hope to leave time for questions. So I bring to bear on this question three separate perspectives. One, all those years I spent practicing law. Two, all the years, and it's hard to believe how many there are, I've spent being a judge, a trial judge, civil and criminal cases. And third, from my years in rulemaking, which have just been a joy. All of these bring me to tell you that you're in the middle of not just what, from my mind, is a semester-long treat, but building the foundation of your professional lives. So let me just have a show of hands. How many of you think you want to do litigation? Okay, respectable number. So you guys should need no convincing, right? None. You guys ought to be fully aware that starting from next summer's job that you hope to get, good luck. Second years that you really hope to get, good luck. On to the bar exam, first day of practice, throughout your life as litigators, you're going to need to know this stuff, clearly. Particularly now more than ever, when every prospective employer you're going to be talking to is going to be looking at you with a critical eye. What can you do for me and our clients on day one? Procedure is the way you're going to know not just the theory, but how to do it. It makes a difference. Okay, you might want to say criminal law, practice in state court. We're going to talk to each of you. How many of you are budding transactional lawyers? Oh, this is my kind of group. But it's okay. It's okay. How many of you think you want to do criminal law? Fair number. Okay. So let's start with summer job. You're likely to be asked to do something that will bear on a litigation problem, you got to know the rules to know how to do it. Let's move on from there. Let's assume you've gotten a job, or you're about to get a job, you're taking the bar exam. Well, guess what, guys? There is currently in the works a new section to the multi-state bar exam. I know this because I'm on the committee writing the questions. And guess what it is? Federal civil procedure. You will be among the first lab rats in this great experiment. That makes me Frankenstein in this scenario, I guess. But in all seriousness, it's going to be part of your bar exam. So start thinking in those terms. This is not something you only have to know to get by your exam in this first semester. You're going to need to know it. So let's move on. You're starting your practice. Day one, job one. You can't respond to any assignment you're going to get in litigation unless you know procedure. You know where to look. You know the rules. You can't, I don't care if you're in the public sector, private sector, working in-house, out-house, you cannot serve your client, much less do it effectively, unless you know these rules. The line between substantive law and procedural law is fuzzy at best. Procedure affects substance. Without knowing the procedure, the substance will be beyond your reach. So this is not just me. Trust me on this one. But you don't have to trust me. I'm just going to quote a great professor of civil procedure whose name you may recognize. His name is Harold Koh, former dean of the Yale Law School, former general counsel of the Department of State under then Secretary Hillary Clinton. So here's his shtick, day one of the first year of law school. Welcome to Yale Law School. It could be any name, fill in the blank. Welcome to Syracuse, or I now discover Q's Law. Okay? You've got 4 classes this semester: constitutional law, torts, contracts, and the one that really matters. This one, procedure. Civil procedure is the ball game. The ball game. Everything comes down to procedure. If you don't know procedure, nothing else matters. I mean, this guy believes this stuff. Contracts. You can have the most airtight contract claim in the world. You don't know how to file a complaint, you're out of luck. Torts. Someone can run over you with a tractor while a TV news crew films it. You don't understand how to take discovery, you'll never get the videotape. Procedure. Procedure. Everything comes down to procedure. I couldn't say it better. I'm not even going to try. Think about all the decisions you have to make in any proceeding or lawsuit. Just think about it real quickly. You're representing the plaintiff. How are you going to pick what court to file it? How are you going to file it? What defendant are you going to sue? How are you going to serve that defendant? That would be Rule 4. Okay? Wherever they may be, whoever they may be. If you're on the other side, how are you going to challenge the plaintiff's choice of forum if you don't like it? How are you going to challenge the choice to sue your client instead of somebody else? How are you going to challenge jurisdiction over your client, service over your client? You have to know both jurisdiction and the rules on the motions to file. Sounds like your first semester class, doesn't it? Jurisdiction and the rules. And you just started. How are you going to draft the complaint? What's the standard? You're on the other side. How are you going to challenge the adequacy of the complaint if you think it needs to be challenged? What motions? What standard? It's all the rule book. How are you going to conduct discovery? If you think it's improper, how are you going to resist it? Electronic discovery. We hear a bunch about that. The rules now specifically address it. They have since 2006. There will be more amendments, I believe, starting in December 2015. Perfectly in time for you guys. That will further discuss the unique problems of electronic discovery. These you really got to know, because much of your experience beginning in litigation will be in the discovery area, and most discovery now is electronic discovery. And you haven't even gotten halfway through the rule book here. Okay? How to get to trial, how to avoid getting to trial, how to prepare the documents you'll need for trial, beyond, how to try it, how to protect the result you get, how to challenge the result the other side got, how to frustrate the other side's appellate efforts, how to appeal. And at every stage, unless you know the rules, you may waive or forfeit important rights that your client has. You may overlook critical obligations that your client has and expose them to sanction, default, or dismissal as a result. There are now 84 rules, not counting subparts, sorry. You're going to have to know most of them, deal with most of them throughout your professional lives. This matters. Okay, state court practice. What do you care about the federal rules? A lot. Lots of state courts either follow the rules or versions of the rules that they get from the federal courts, and the case law draws heavily on the federal court cases, even if the rules vary. You're going to have to know it. And there are cases that spend a whole lot of time moving between the federal and state systems. So if you're in state court and you want to stay there, you better know how to resist removal. If you're in federal court and you really want to be in state court, the reverse applies. I have a thriving docket of motions to remand. You're going to have to know that. It's again back to jurisdiction, it's back to rules, it's back to motions, and knowing how to present them and resist them. Criminal lawyers. Well, you guys, you're stuck with us too. There are lots of civil proceedings that proceed or relate to or grow out of criminal actions. You got to know those. And discovery in the criminal area, the more it becomes electronic discovery, and it does in complex cases more and more, the more the criminal lawyers and judges look to the civil model on how discovery is done for guidance. Subject to a lot of different interesting constraints, like constitutional obligations to disclose exculpatory and impeachment evidence. I know that's next year, but it's one of the joys that awaits you. But they borrow heavily. You'll need to know it. So I don't really care what kind of litigation you want to do. You got to have this stuff. And transactional lawyers. You guys have two major obligations lying ahead. You're trying to get done what your client wants to get done. To get the deal, whatever it is, get the transaction, get the whatever the contract arrangement, fill in the blank may be. You're trying to accomplish that goal. But you're also trying to protect, to envision downsides and risks and pitfalls, and do what you can to prevent them from occurring and to address them if and when they occur. You got to do that. So lots of contracts, for example, will have clauses that recognize that there may be disputes that arise out of the contract and put in place provisions that say, we agree in advance We don't want to go to court, or we only want to go to particular courts. We want to go to only federal courts in the Southern District of Texas, Houston Division, or we want to only be in court, doesn't specify state or federal, in X jurisdiction. Some of these clauses agree to stay away from any court whatsoever and instead go to binding arbitration. Some of these clauses specify a detailed form of dispute resolution, ultimately winding up in court, and then specify what law will apply. Who will it bind? There are lots of provisions. So how are you going to know, and how are you going to advise your client whether they should agree or not? What the risks are? How to draft the clauses to either be enforceable or give you some flexibility? How are you going to make the decisions? Civil procedure will give you the beginning of those answers. And let's talk about papering the deals. That's what your job will be, in large part. That's important. How are you going to know what to keep and what to throw away when you're done or during the process? You got to look at the discovery rules on spoliation. What are my obligations to preserve certain kinds of documents in the event this thing winds up in litigation? And if I make the wrong decisions, what's going to happen to my client? What could happen to me? Because there are professional consequences that can occur. So you owe it to yourself, as well as your client, to be mindful, to be careful, to be right in the decisions you make about what drafts you keep, what drafts you toss, what notes you keep, electronic or otherwise, particularly electronic, because if you don't keep them, the emails, whatevers, they may not be around in 5 years. Your system may change. Your computer may be tossed. You may be wearing Google glasses at that point. I mean, who knows? That's the point. What are you going to do? And how are you going to know? Civil procedure, the discovery part of the book, will help answer those questions. So you transactional lawyers, you cannot escape. You too. For you too, this really is the most vital course you'll take in law school, well beyond the bar exam. Now, I'm not condoning the obvious. These are rules, okay? This is not fiction. This is not a great novel. This is not beach literature, okay? There are lots of details. They can be, let's face it, boring. Rule 4 will never be an easy read. It's a guaranteed insomnia cure. But although there is clearly tedium, there's a whole lot more. Civil procedure, to get back to where I began, procedure and procedural rules. This is the brain, the heart. It's the soul of any court system, as much as the Constitution itself, perhaps more. Procedure, studying procedure, and the rules of procedure let you think about the most basic questions any government putting together a system to resolve disputes, civil disputes, must answer. Our government had to, and we still do. Who has access to courts? And under what terms? That's the pleading part of the rule book. Who can be compelled to participate in a lawsuit? To comply with the process? I mean, what gives me the authority to tell you, you will produce these documents, or else, and have that else be full of teeth, sharp ones? Who can be compelled to participate, subjected to the sanctions of failing to do so? Who will enforce that? and how? Who can be bound to the outcome? Bound. That's an important concept. That's jurisdiction, both subject matter and personal. That's what you're studying. How will information not available to one side, critical to the claims or defenses of the other, be obtained from the side that has it? On what terms? How are you going to get what you need? That's part of our democratic society, being able to get information otherwise not available. That's the discovery part of the book. How will cases be resolved? That's a vital question that civil societies have to answer. It's a universal question. What happens when your citizens disagree? What happens when they disagree with the government? State, federal, local. What happens when different branches of government disagree? How are those disputes going to get resolved? That's the trial section of the book. And how will disputes about each of these issues, access, pretrial, resolving, trial, how are those disputes going to get resolved? Well, that's the motions part of the book. The rule book is our answer. The United States of America, one of the greatest experiments in democracy the planet's ever seen. That's our answer to those questions. That kind of makes Rule 4, despite all of the details, look pretty interesting. Through procedure, you are grappling with the most fundamental issues of our civil justice system, issues we share with every other society, every kind of government on the planet. As lawyers, no matter what practice part, no matter what part of the country you end up in, as citizens, it's good to know civil procedure. No matter what area, you need to know the vocabulary, the concepts of jurisdiction, of all of the parts of the rule book. So I'm going to step back briefly in the little time I have left and look at how these rules came into being. Think back to 1934. Okay? That's a long time ago. Civil procedure then was much harder than it is now. Civil procedure then was a crazy quilt. In the federal system alone, different rules in every federal court. No consistency. Usually the rules were patterned after the state in which a particular court was geographically located. Okay, dynamic conformity, they called it. It was a mess. And it was formalistic beyond belief. So you had forms for law, you had forms for equity. If you didn't have the right form, the right writ, the right template for the right kind of claim, you were out of there on formalistic grounds before you ever had the substance addressed. It was complicated in ways that were not designed to further the resolution on the merits necessarily, but to set up a bunch of hurdles. There was growing impatience with that. So it took 20 years of concerted effort, but in 1934, Congress passes what becomes effective the next year, my favorite treaty in the world, the Rules Enabling Act, which recently had an anniversary. So the Rules Enabling Act is a kind of treaty between Congress and the judiciary, two co-equal, theoretically, branches of government. So Article 2 says to Article 3, you know what, this is technical, drafting rules, this requires expertise, we frankly don't know much about it. You guys, we're going to delegate to you the authority to write the rules governing your internal procedures. But we got two caveats. Number one, you can only do procedure. They cannot enlarge or abridge substantive rights. Okay? Number two, limit. We are going to keep a watchful eye over you. And even though we are going to allow you to write the rules and will allow them to become effective if we don't do anything to stop it within a given period, we are going to reserve to ourselves a kind of a veto power. So if during that period for review we really don't like what you're doing, we'll stop it. But unlike most legislation that requires an affirmative act by Congress to pass it, this requires Congress to do nothing in order to let rule changes or rules become effective. And Congress has increasingly shown itself quite adept at doing nothing. So it's turned out to be a really workable process. It's a power-sharing deal, and it has endured with a lot of changes that have, I think, been entirely helpful since 1935. So fast forward. Civil procedure is the first set of rules. How gorgeous is that? 1938, that's when these rules get written. And they are written by a small group of white guys sitting in a conference room. They have no diversity, they have no judges, my God. It's only law professors and lawyers. Many of them went on to be distinguished judges, but they were not so endowed at the time. And there was no accountability, there was no sunshine, there was no public input. They just sat, scratched their heads, and thought, what are we going to do? And what they did was actually nothing short of revolutionary. It was quite breathtaking. What they did in the 1938 version of the Federal Rules of Civil Procedure, first one, number one, single set of rules to apply in every federal court across the country. 94 districts, you walk in, you know what the rules are going to say. Huge. United the courts. Number two, they merged law and equity. No longer are you going to have separate forms occupying volumes governing cases in equity, and then a completely separate rule book. It's like a kosher kitchen, right? For cases in law. They're merged. And number three, you are going to adopt a truly new system of flexible pleading and broad discovery rights, broader than was true in virtually any jurisdiction anywhere. Think about it. Think about the enormity and the visionary scope of those changes. One set of rules, small committee. So they get through, and they're off to the races. Other rules followed: criminal procedure, appellate procedure, bankruptcy, and evidence, some controversial. But these rules are not static. Think of how different the world is now than it was in 1938 in ways that directly affect civil litigation. It's hard to imagine and impossible to overstate the differences in the world between 1938 and now. The rules have kept up, not simply by changing the case law, but by changing the rules themselves. So under the Rules Enabling Act process, there is a group of committees that have been established to monitor how the rules are operating and to amend them if a decision is made that, A, there's a problem out there that the current rules are not handling well, and B, it's a problem we can solve by changing the rules, either changing what the existing rules say or adding new rules. There are lots of problems that you can't solve by changing the rules. You need something else. But if both of those questions are answered yes, there's a process in place to do it. So you have the advisory committees for each of the rule sets. They're composed of judges and lawyers and academics selected from all over the country. That is meant to be a broad cross-section, different types of viewpoints, different types of perspectives, practice backgrounds, but with a single shared commitment. Your clients are left at the door. Your narrow advancement goals, I want to advantage this type of litigant as opposed to that kind of litigant, those are left at the door. You're there to inform with your different perspective, but to improve the system as a whole. And it's remarkable how much the committees strive to live up to that ideal. The advisory committee has an oversight committee, the standing committee similarly chosen. So here's the process briefly. Suggestions come in. The committee itself makes suggestions through this monitoring function. They look at it hard, often with detailed empirical study, efforts to become informed from lawyers, practitioners, public, private, big, small, from all over the country on the nature of the problem and the kind of problem it is. And then they work up a proposed amendment if they think that's appropriate. And then once they get the wording they're satisfied with and the explanation they're satisfied with, the proposal goes up to the next committee, standing committee, and they conduct essentially a de novo review. Is this something that's a good idea? What are the likely unintended consequences? What are the likely intended consequences, and do we want them? Are we comfortable? Is this as good as it can be? Does it raise potential unfairness? Is it potentially beneficial to one side to an extent that raises a concern about imposing improper costs or disadvantages on another side? What are we going to do about that if we're worried about it? So all of this conversation occurs. And if they are satisfied with it for one purpose, then it gets published, and this is the purpose, for a period of public comment. And by the way, these are all sunshine committees. Anybody can come listen. All of the proceedings are made available, now electronically. So what was theoretically a sunshine committee for decades, thanks to the internet, really is a sunshine committee now. So the standing committee says, great, publish this for public comment. And it goes out to everybody. And in areas that are heavily used, like discovery, pleading standards, class actions, or viewed as really going to make a difference in cases that really make a difference, you get a big response to the invitation for public comment, both in writing, posting on the internet, or 3 public hearings. Anybody can come testify. So when Congress has a hearing, Congress says the following 3 people will testify. The Republicans pick 3, the Democrats pick 3. You know exactly what they're going to say before they show up. They don't want to hear from anybody else. Nobody else is invited. Okay, they can write letters, but P.S. who's going to read them besides some 25-year-olds sitting in Capitol Hill? No offense. But this is different. Anybody who wants to can come and talk, answer questions, share with the committee their perspectives, concerns, and experiences. So this occurs, it occurs over a 7-month period. Period ends, advisory committee takes all the comments. There can be hundreds, thousands of them. Reads them, digests them, makes revisions. The revisions go back to the full committee. The revisions get revised, often many times. If they are satisfied, the members of the committee vote in favor, goes up to the standing committee, same kind of review. From there it goes to the Judicial Conference of the United States, made up of the chief judge of each of the circuit courts, a district judge representative from each of that court, and the Chief Justice of the United States. They got to agree. If they agree, then it goes to the Supreme Court of the United States. They do a review. If they agree, it then goes to Congress. And if nothing happens for 7 months, think back to what I said a minute ago, it becomes law. It's part of the rule book. It is longer than the gestational period of an elephant. Okay? It is deliberately slow, but it is careful. There are so many filters, so many reviews, more than you get for a constitutional amendment. The level of quality control is pretty good. That's what made your rules. So treat them with respect. I mean, you don't have to, it's not, a sacred book, but it represents efforts by many dedicated people, hard work, and a shared commitment to making it a good system. And it's easier now than it was even a short time ago. 2 things that the committees did that made it easier. One, the style project that you heard about, we put the rules into plain English. I mean, trust me, these are easier to read, a lot easier. One thing we did was just format them differently so that instead of impenetrable blocks that went on, paragraphs that went on for pages, the physical structure of the rules is displayed in the way they are formatted on the page. So as you look at the rules, look at how they're physically laid out, and you will see how they're organized. Because we put them that way so that there was a clarity to them that hadn't been there before. Plus, we took out all the rules that nobody knew what they meant anymore. We even took out the reference to phonorecords that had been in the books. The word computer wasn't, the word electronic wasn't, but we had phonorecords, no more. And we also did a project which made consistent across every set of rules and clear how to calculate deadlines. Okay? This was the Associate Rescue Project. So you wouldn't miss deadlines simply because the rules for figuring them out were too complicated or too unclear. So you're welcome, we cleaned up the beach a little bit. There are lots of new proposals. I don't have time to go into some of these new proposals. I hope you will study them. Some of them are quite controversial. One of them deals with an effort to clarify and make effective a part of the rule book that's been there since 1983, so-called limits on discovery, to make discovery proportional to the reasonable needs of the case. Since 1983, this has been part of the rules, but not well enforced or understood or even invoked. We decided we couldn't write it in red. That was not an appropriate way of rule drafting, but how to make this something that had meaning. So there's been another amendment to try to achieve that. A lot of controversy over it. Be very interesting to see. These are in the middle of the process. They're now pending before the Supreme Court. They've made it through the first hurdles, made it through the public comment period. Stay tuned, because this will matter to your practice if it becomes effective. So I'm just going to leave you with a few other thoughts, briefly. The rules committees can't do what they did back in 1938 now. They cannot achieve revolutionary, breathtaking change. Some view that as a real indictment. The rules committees, the rule structure is going to go the way of the French monastery, the French monarchy. Sort of worthless. I don't think so. And I don't think that the fact that we can't revolutionize the system is bad, that we operate incrementally to make improvements and adjustments. Working in smaller steps means that in this very complicated world, with lots of different kinds of litigants, lots of partisan divide, lots of disagreements about how we ought to be doing things, it means we act only after we really understand what we're doing. Working in small steps means in this bitterly divided world, we accomplish, we change only with broad support. It means that with that, you either work with all constituents, all parts of the bench, the bar, the academy, Congress, the executive branch, to gain their support, or you do nothing. And one answer to those who criticize the current system for not doing more to change it dramatically and fundamentally is that it's not wise or feasible to do that. And I don't think that's bad. Final thought, I promise. The fact that we're still trying to get these rules right reflects two more things that civil procedure teaches. First is how dynamic and alive our system is. We have to change the rules. As law changes, as society changes, as business, government, technology, all those things change. And second, you can't solve everything with rules. They're necessary, but they're always imperfect. There's always a set of facts, a novel situation that the rules will be inadequate to address, didn't foresee. You need creative new lawyers, bringing new perspectives, new experiences, to read them, to apply them effectively and well. There's a great scholar who was on the first committees, great rulemaker. His name was Benjamin Kaplan. He went on to be a justice in the Massachusetts Supreme Court, died just a couple years ago at a quite advanced age. Here's what he said, and I've never found a better quote. No one expects of a rule that it shall solve its problems fully and forever. Indeed, if the problems are real ones, they can never be solved. We are merely under the duty of trying continually to solve them. That's a responsibility and a joy we all share. And what does civil procedure teach us about us as lawyers? No matter where we practice, civil procedure and the rules and the cases teach us that some of our greatest satisfactions in the practice of law come from as much from the process as from the result. The people we work with, the issues we struggle with, are what makes this profession meaningful, satisfying, vital. Law can be tedious, it can be the stuff of endless detail, it can be stressful, and it can be petty. But it's the issues and the people and the process that make it the stuff of a really good life. So you look at this process, we're continually changing, we're monitoring, it's never going to get to be the way we want it. There's always imperfection. But we don't settle for the way it is. If in your practice what you are doing is not working for you, don't settle. Learn from what civil procedure teaches. Whatever your future holds, whatever your anxieties about jobs and opportunities and security may be, you don't have to settle for a life in law that you dislike. You should not. You have more important work to do and more satisfying work to do. You should find it, and you should do it. You learned it here in civil procedure. Thank you. And it's always true, thank you. It's always true in civil procedure that I talk way longer than I should have. So if you have questions, they have my email. Send them to me, please. And good luck.